Welcome back to the second hour of the Newspaper Review on Citizen TV. You are watching the Power Breakfast Show. And of course, it is the 28th day of August 2017. It's a Monday, and this being the 10th day of the 14-day process in which the Supreme Court constitutionally has to listen and determine a presidential petition. A busy day because the hearings officially start today. We expect them to start at 9 a.m., which is a little under 2 hours right now. That's something that we're following keenly. We have a team at the Supreme Court and we'll cross over there as soon as we can get an update from them. But of course, we carry on now with our newspaper review, the big topic being the Supreme Court as expected. And I'm now joined by more guests in studio. On my far left, I'm joined by Kibe Mongai, an advocate at the High Court. Welcome to the broadcast.
Thank you.
In addition, Joy Mdivo, pleasure to have you here also, an advocate. Welcome to the broadcast. And Kai Kissinger, we were here with him before the break. He carries on. I don't think I need to welcome you again. Thank you for staying with us. Thank you for staying with us on the program. And I'll start with you, Kibe.
Yes.
I'll bring you into this particular discussion. Before the break, we were talking about the merits and demerits of the 14 days set by the Constitution in which the Supreme Court can listen to and determine a presidential petition. Where do you stand on all this? Of course, it's in the Constitution, so there's nothing much that we can do for now, but people have, in light of what's happening, discussed whether 14 days was a very, very good idea or whether it's something we'd like to relook at in the future. Your take?
I think my take from the experience of 2013 and the experience we are currently having in 2017 is a very bad idea to say that you have 14 days. The reason for this, for example, you see that even for an MCA position and even a member of parliament, you have 28 days. And you are just dealing here with just a few polling stations. Now you can imagine to be able to overturn a presidential elections on the basis of a petition that one must do within 7 days. The petitioner's advocate, in my view, they are in a very bad situation, and the worst thing that you can be able to have is actually to be the party petitioning an elections.
Are you under more pressure?
It. Yes, you're under a lot of pressure.
Okay.
You're under very little time. This is why you see the issue of late filing of documents, where you feel that probably, even in 2013, you remember this affidavit that came later, it is because sometimes it's not humanly possible to get all the evidence within these particular days. And moreover, even in 2013, we saw that the Supreme Court itself was minded by Justice Mutunga. Even when we criticized that decision of 2013, it is important to forget that the instincts of the court, for example, were let us do some scrutiny and verify the results. But because of the time limitation, even that process could not be completed. And because it could not be completed, even where the judges, to me, appeared to see that there was something wrong here, they could not be able to go along with doing substantive justice in the case. And even now, the decision that was deferred yesterday to today, I see an element of that. Because, for example, some of the things that may be weighing in for the judges would be this. Assuming you allow this kind of scrutiny to go on, it amounts to something like entering into a dark tunnel, where you don't know what comes out of it. How are you going to deal with it? Bearing in mind that by Friday you must give the decision.
That's right.
So that one of the biggest problem, and you have seen this weighing on the minds of judges over and over again, that look, the key issue now appears to be we are making the prime issue, the Trump issue, the issue of having a judgment on Friday appears to be trumping justice. And the whole idea again is because of the law. So if you have a law that on the face of it, because if you ask me, it is like climbing Mount Kenya, and you tell somebody, let's climb 10 kilometers of Mount Kenya, the petitioner is supposed to do it uphill, and the respondents are supposed to do it downhill. I don't think there is any fairness in the process, if you ask me. Because you see one side, and you can even see even in the issues that have been distilled by the petitioner. The petitioners have 28 days. 28 days, even in the 28 issues, yes. Even those 28 issues, if you ask me, because I've gone through them, I don't think 5 hours is sufficient. And remember, the legal burden to show that there was something wrong with these elections rests on the petitioner. That's right. Finally, on the issues of the framing, there is one issue that people seems to be forgetting when you are saying these are the issue. one of the issues that ODM has taken up is the issue of the constitutionality of Section 83 of the Elections Act. This Section 83 of the Elections Act, what it says is that the democratic will of the people is going to be upheld by the court unless you can be able to prove that there are such substantive irregularities and breach of the law as to invalidate it. This speaks to the issues that I was raising, that the majority of the issues of ODM is that there was non-compliance with the law by Raila, is that there were non-compliance with irregularities that are there. But you cannot see in these particular issues where Honorable Raila is saying that, for example, like he had said in 2013, the main issue was that Uhuru Kenyatta did not cross the 50+1 threshold. But as of now, there does not seem to be any allegation saying that the democratic will of the people could have been in his favor. And therefore, that is why, in my view, Section 83 becomes important, and that would be the major challenge of the judges, namely this. If it doesn't appear, you do not seem to have received sufficient evidence that the people of Kenya wanted a different president from the one who appears to have been elected. No evidence seems to be coming so much on that score. And then on the other hand, you find that there was a substantial non-compliance with the law. How do you resolve the key issue? And that is where the issue of Section 83 becomes important. And therefore, do the judges have enough time to resolve these issues?
Bring us back to the big question.
Yes, let us also feel for the judges, that the judges, so to speak, are also on trial. In fact, because within these 14 days... That was actually going to be my question to you. Let me wait for it.
You've talked about the burden on the petitioner.
Yes.
The time that they have, the 5 hours to, in a sense, compress the 28 issues and convey them appropriately to the 7-judge bench. But for I also feel that the bench as well also has a lot of pressure, and you saw that coming up over the weekend, and that ultimately it will be looked up to them to hear everything, be able to understand all the information and then give a ruling that will make sense.
Yes, but just before I delve into that, there's a place I want to differ slightly with my brothers on the issue of time. The reason why the time is made so short is, of course, because people are waiting for a response. People are mindful that this is very critical. But on the other hand, Kenyans as litigants, we are not very disciplined in how we frame our matters. If you're a petitioner and you come with 28 issues, it becomes difficult for you to zero in on what your major issue is.
Although it's your right to frame as many issues. It is your right to frame as many as you would want to. But any successful litigant will tell you, and when you go before a court, the more clear and succinct you are with what you want, the easier it is for the court to know how to handle your... For example, the 900-page affidavit that was disallowed last time. Is this because even humanly possible, how are we distilling a 900-page document within 14 days? Do you have a point? Go ahead and make it emphatically, make it clearly. Because if you're discharging a burden of proof to such a high standard, you'd rather major on something that you're sure by the time you're done, you have finished what you need to do and you've done it well. But when you've got too much to do, then you spread yourself too thin. At the end of the day, you are not successful, not because you did not have a good case, but because you tried to hit every single thing that you thought needed to be hit. In such a petition, picking 2-3 big things and dealing with those emphatically gives you a higher chance of success than trying to deal with every single thing that's not. Because what Kibe talked about, Section 83 of the Elections Act, there are some of those things where the court will say it's true, there was a mistake there, but we don't think it was big enough to affect the outcome of the election, and it fails on that point. Now, that means you ought to not have started with that to begin with. But now moving on to what you're saying, there was a criticism with the Judge Mutunga-led Supreme Court bench last time, because the judgment that came out seemed to lack a little bit in substance, and it did not do much jurisprudentially. It didn't develop us as a country jurisprudentially. And for me, I remember I read it and I thought to myself, it was a bit of a letdown. But this time round, one thing that we have different is we've got people who have been career judicial officers on the bench.
Judge Maraga joined the bench, I think, 2003, as well as Judge Lenaola. Both have served with a lot of distinction in whichever stations they have been. We have also seen the growth, for example, of somebody like Judge Ojwang in the bench. So it's one of those benches that you can tell, even with how they discharged with they dispensed with the rulings yesterday, with the applications yesterday, you could tell a lot of thought process went into it. They were also very succinct in what they were saying. It was not those pages where you're reading for 3 hours a ruling. It was, you know, this, we are cutting to the chase. We are aware there's timelines. We are aware that there's, and even how they have handled their matters. When the applicants and the petitioners and the parties, when they try to sort of bully them, they have been very firm and said, look, don't feel sorry for us. When we want to cry, we will cry. But for now, we are able to handle this. We have not been sleeping because we've been studying your case. So I think this is one bench where, yes, they are on trial, but in my opinion, they have sort of, they are aware.
Okay, they're aware.
They're aware, and they have also gotten to a place where they do not want the indictment of the previous petition to be visited upon them.
Okay.
Because, I mean, as the highest court in the land, we need to have, it's a law-making court, the Supreme Court. So they need to develop jurisprudence, because the rest of the courts in Kenya are bound by what they decide in the Supreme Court. So, and I'm glad I see that the cloud the size of a man's hand, that this ruling on Friday is going to be actually something that will grow even the legal profession. Yes, because that's what we need right now, moving forward. And also with the issue of time, as Kenyans develop politically, we will get to a place where 14 days will be plenty.
More than enough
right now,
time.
it's the style of how we do our trials that makes it impossible. But it will come to a time where somebody will just have the one point, hey, on this point I think it should fail. Or they are just looking actually for a legal opinion on how was this conducted, should this move. It may not be necessarily to overturn the election. It may be, you know what, we just want this issue clarified for the sake of the future. So we are growing.
That's a prophecy that hope will come true sooner rather than later.
Let me tie in something on what both have said very briefly on time management, which seems to be a constraint of the Supreme Court compared to even 2013 and 2017 right now. But when you look at the rulings they made yesterday, they are very cautious of that. They are aware that time is of constraint, and that's why they are limiting the number of times. Now, the issue that both have talked about, Section 83 of the Election Act, has actually been given specifically to the Law Society of Kenya, and they have been told, we are limiting you as amicus
to that.
Only give us issues on Section 83. Because you are an authority on these issues at Law Society, give us an issue. What does that mean is that the court is now trying to remove itself on doing a lot of research on that section. And as Kibe said, and Joy has said, and I said it earlier, they don't have a lot of time on this issue. But now, look at the time allocated to LSK. They've only been given 20 minutes to deal with that very huge issue, which for me I think is a very big thing with the Muigai. Look at the limiting of Gideon Muigai was been given 20 minutes as well.
And of course he's also been limited to a topic.
Issues of Court of Appeal. What that means is that the court is aware of the challenges of 2013, and they're trying to remedy it, and they're limiting even amicus. Because I think in 2013 we made a very big mistake at the court, in the sense that the court allowed amicus to run the show, so that you saw that my good professor Gideon Muigai had everything and all the freedom to punch holes in everything and add value to. Of course, it's a good thing, and also the limiting of amicus to this participation. So they are aware of the time constraints.
Okay, let's take a look at other stories. Something that you may not have noticed during the whole Supreme Court process is the presence of observers. They were mentioned briefly, but let me just mention who is there, and I guess the importance of what is happening in Kenya for Africa. Chief Justice David Maraga yesterday introduced to the court, yesterday being Sunday, members of a high-level international mission that is in Kenya to observe the proceedings of the presidential election. The mission is headed by the former Chief Justice of Zambia. Other members introduced were retired Chief Justices from Zimbabwe, Botswana, and human rights lawyers from Uganda and Zimbabwe as well. This group is mainly drawn from the Africa Judges and Jurists Forum, who in partnership with the International Commission of Jurists, ICJ Geneva, are in Kenya to observe the proceedings and a trial observation mission, TOM. How much pressure does this put our nation? Bearing in mind, I believe they've not just come to observe, I trust they've also come to benchmark. And Kenya being seen as, I guess, a light in terms of democracy, jurisprudence. What does that say for us as a nation?
I think for me it's a proud thing, because even the interest of the international community in the Kenyan election and the many observers who came is something to show that Kenya is a kind of country, because of its regional importance, that if democracy does not work in Kenya, probably we do not have a good chance that it will work elsewhere. Remember, very many people, and these are European countries, they claim they had no sufficient money to go and observe elections in Zambia. There was no much observation in Angola, which also did the elections last week. Again, for the same reasons, that more or less, though these are things that are not spoken loudly, those are not considered to be real democracies, and which will be democratic countries.
Those are your words.
Yes, they are. I'm not pretending they are.
Those are your words.
They are my words.
Carry on.
Yes, but again, because it's the same thing that we may all say. Ethiopia is a democracy, and Uganda, but even the way even they do the elections, the kind of challenges that Besigye is condemned to in Uganda, the kind of shenanigans we saw during the last elections in Tanzania, you don't have those things in current Kenya. You had them in 1992. So in many ways we have advanced, and therefore that's why even when the benchmarking, freedom of expression, and even an election environment, and that is why now when people come, it should actually be a moment that should make us proud that even the election observers, and this is irrespective of what the court ultimately decides, the common verdict of all election observers, both from Africa and from outside Kenya, was that this was a good election, and Kenya had a shining moment to be emulated across Africa. Therefore, for me, this is another good sign, and I hope, because like my colleagues have said, I really hope that we should have a quality judgment, because I think the advocates did a good job in 2013, but the judgment that came out was not a fair reflection of the arguments that came out, and therefore I hope and I trust now that we have better caliber even that has come to the Supreme Court, that the quality of this judgment would be happy, where the winners can say and feel proud. That is a judgment that vindicated our win. And the losers, of course, to feel that our issues were heard extensively, and there is a good judgment to show we did our best. Okay? Yeah, so for me that is important.
Joe, your take again on the observers that are in the country?
In fact, the important thing to remember with observers is that, like you said, they do benchmark, but also they help to lend credence and credibility to the process. Because when you have a third eye looking in, if it is just the Kenyans, it can be said, oh, this judge was leaning this way, this judge was leaning this way. But somebody who looks at it purely on a legal perspective, and I'm glad that they're getting a jury of peers, so to speak. It's their fellow judicial officers who are coming in, rather than pedestrians, for lack of a better word, laymen trying to adjudicate the process and say, was it fair or not? Because many times the things happen. I mean, we've been sitting in court with Kibe and Kissinger for a while, and there are times a ruling will be made that sounds perfectly reasonable to the lawyers, but the parties are left aghast thinking that was such a travesty. So when you have,
so it is your role to actually explain to them
observers,
exactly
yes, when you've got observers who are peers, they'll tell you, no, given the time constraint, given the quality of evidence, given the way the evidence was led, and given the time that they were given to consider the evidence, we think that they did a really good job, or we think they did not do a good job. And some of those reports would be what would even be necessary. For example, if we need to change the constitution to enlarge time, or if we need, for example, to give more flexibility to the parties, maybe say time starts running from the hearing rather than from the filing. That's what such a mission would do. And also for the Kenyan judiciary, I think it's very important, because we've been struggling for a long time to clean up, quote unquote, the image of the judiciary as not just free of corruption, but also a level of competence. And we have seen a lot of work going into the judges, the Judicial Training Institute, and even the judges themselves, taking a lot more pride in their work and being a lot, because there's a time, I mean, judges had no problem giving you half a paragraph of a judgment that made absolutely no sense. And they're like, you know what, if you don't like it, go and appeal. But these days we are seeing a more concerted effort, and I'm glad that even when others are coming to see it, it actually is a vote of confidence in our judiciary by other people in the continent. And for me, I'm hopeful that even the report that they give afterwards will be something that will help us improve moving forward.
Okay. Kaika, I'll allow you to comment on the observers that are in the country. But in addition, how much pressure do you think there is on the Supreme Court judges, each of them, that on September 1st, when they deliver the ruling, that they would each come and share what they ruled individually, rather than a summarized judgment, and then more time is given for them now to to come up with the individual rulings? How much pressure do they have right now in regards to that?
Okay, I'll answer that as a third question. But the first thing is to put input on to what my colleagues have said, and I totally agree with them.
Okay.
And you'd recall that the 2013 judgment, when it happened after the Supreme Court made the decision, Zimbabwe went into an election, I think a year later. And when you read the Zimbabwean presidential election, Supreme Court ruling, it mirrors into the Kenyan one. So Kenyan imported that jurisprudence to Zimbabwe, because in law is you carry from other jurisdiction you learn. So what Joy and the Kibe are saying,
we've also been accused of importing from other countries.
Exactly, and what Joy are saying is the issue of quality which we had talked about, so that if as a Supreme Court in Kenya we do bad judgment in terms of quality that is not very good, then it finds itself being imported in other countries. Remember that I belong that school of law or thought which believes that our election laws, and Kibe touched on it, our election laws in this country, we have over-reformed it. In fact, if you ask me, yes, if you ask me whether if you ask me whether we still need reforms in the electoral process, I'm not so sure which areas of reforms we need. We've done so well in terms of electoral reforms, we've done so well in terms of laws. So what we are then expecting is a very interesting jurisprudence, and Kibe talked about, and Joy talked about new imports in the Supreme Court. We have very good judges right now in the Supreme Court.
Yes.
If you look at Justice Lenaola coming to the Supreme Court, Justice Mwilo and Justice Maraga, it's fresh blood. So we need to see the spirit of the Supreme Court Act, that the Supreme Court is meant to bring out issues that are very jurisprudence sound. Then now that means that we should be able to import this into other countries, because remember that Zimbabwe is going again into election next year. So we hope that we hope if history repeats, they should be able to pick. So we are looking forward to that. But then before I answer your question, there's another thing about the 6 Kenyans have been accusing the 2013 decision as to mean 6-minute judgment. And it has been, it has been, I think, a misconception and a bad verdict on the Supreme Court, in the sense that the rules allow for the court to make that precise judgment.
That is correct.
Then are given 14 days. 14 days, that's right. They are given more 14 days to prepare a final judgment. So I think the Kenyans were not told that the 6-minute judgment that Justice Mutunga and the court read was just for the purposes of finalizing the matter, but then there was another judgment that came out.
It reminds me of when IBC Chairperson Afula Chebukati had to read the results from all the constituencies, and Kenyans were very unhappy with that, but it was part of the law.
Exactly. So Kenyans need to understand that the judgment was not the 6 minutes, because all Kenyans say it was a 6-minute judgment, a 5 minutes. No, it wasn't. There was a judgment that now
came after that, but it had been over, I think, passed by events.
Exactly.
So
now to go to your question, and my colleagues will input, the rules do not restrict the court in terms of what kind of judgment they have to write, in the sense that
for Friday, yes,
in the sense that they may adopt an unanimous approach to write the judgment. They conference, in most cases all judges conference and agree what is your opinion on this. So if we are invalidating the election, then we all agree we are invalidating the election. If we are dismissing the petition and so forth, so they agree. If there are any dissents, then dissents will be there, and they will count and know what are the dissents. You know, the number is uneven. We have 7.
Exactly.
And at the end of the day, not all of them need to sit, actually. It's just good that all of them are sitting. The law requires 5 to sit.
Yes, that's
5 to sit. So they are all required. So I don't know how the judgment will be. One can only guess that probably in the spirit of 2013 it could be unanimous, or
could they, just like we've seen that they've looked at 2013 and are avoiding what may have been condemned in 2013, could they also decide that this time around, if in 2013 a summarized judgment was given, let's do something different, let's give a more comprehensive judgment, let each
it will depend with their conferencing.
Okay.
It will depend with their conferencing. If there are, for example, 2 judges who will differ and do a dissent opinion, it will be allowed. They will differ and do a dissent opinion. But in law, the dissent doesn't. Then, if it's few, the dissent is not the judgment of the court, and they will go by the majority. So it's very difficult to comment. But my colleagues can.
The issue that I need to point out, When we examine the decision that is going to come on Friday as just a legal issue, we actually miss quite a lot. Because remember, from 2013, many lawyers could relate to the fact that it was difficult for Raila Odinga to win that petition. But for many people, there was some difficulty because this is a political verdict that is being made. And therefore, for me, and that is why even yesterday's rulings, you could see that they were trying to ensure that there was largely a draw.
Yeah.
You got some, you got some. So they had a good start. But the breaker may be this morning. Whatever that they rule, you would have one group thinking that we've gotten something substantive.
You cannot have a draw. You cannot have a draw this morning.
This morning.
There will be
it will be difficult to have a draw, and it will have a lot of impact on what is decided finally. And that is why on Friday, because this is a political decision, the whole idea that the hopes that Kenyans tie, because to the ordinary Mwananchi, there is still a glimmer of hope that it is possible to reverse this decision, the verdict of the people that was made during the elections. Yet the truth of God, and what people are not being told, is that the powers of the Supreme Court to change the verdict is actually very limited. So that this is a group that can actually do so little in changing the verdict, yet there is so much hope that people mistakenly believe that it is easy to overturn the results of an election. And that is why, for me, when I say that, because another loss to Raila Odinga, you can imagine how much damage it might do to the credibility of the Supreme Court. And therefore we are left in a situation that ideally, I would actually want every judge to do their own opinion on how they exactly perceive the issue. And personally, I think for the trial that I see the Supreme Court being under during this week, if you can have 2 or 3 dissents, I think it is good for the history, so that we keep some hope that it is possible that a court may have a difference of opinion in any matter, and it is still possible to overturn the elections. Whether that is whichever way things will go. Yes, whichever way things would go. But more importantly, I still insist that this idea of where we are all like held hostage by time, because truth of God is the key issue that, for example, for me would turn the elections would be this. Let's go to Asingishu. Let's ask yourselves, if they say you had 93% of the votes were cast, and you have doubts about that, without recounting those votes, there is no court that is ever likely to say that on the basis of Forms 34A and Forms 34B that we are going to overturn the election. So you think the truth of God is you can't count those votes, because at the end of the day, yes, the real pressure that the court is acting on under is this, that there are some ballots there. The count of those ballots is saying so and so won the elections. So that without really counting those ballots and without having rules of procedure that allows you to do that, no judge would ever, in my view, feel confident to overturn the results of an election. So that's a real issue to me.
But that said, one thing that we, even as Kenyans, need to understand, there are some things that we can do to mitigate this conundrum prior to the elections. Audit the systems, understand the systems, let the systems before the election work. Because when you come to a situation now, it's after the election, and now that's when we want to ask, were those things counted really properly? In my opinion, it's a waste of our intellectual capacity. We should be auditing other things, whether, for example, should we be looking at a collegiate system? Should we be looking at a weighted system? Those are the things that should be chewing our minds now. Not how many votes were counted, or did the Kim's kits work, or the computer systems did they work. I would say, Joy, that if any, if the petitioner has questions they feel should be discussed, I think again it's in their right. No, I'm not discussing in light of this particular petition, but generally the whole process. As politicians, as political parties, as stakeholders in this process, let us try and work prior let's work smarter, not harder. So that beforehand, make sure, have you interrogated the systems? Do you understand them? Do you see the loopholes? Do you understand where the loopholes may be? Have you sealed them? Like what we saw court doing, NASA doing very effectively. Going to court and making sure that the IBC is on top of things. Because if you do that prior, then afterwards you're left dealing with the intellectual questions, which is what an election petition should be. Before
it should be, okay.
It should be,
okay.
yes.
Okay.
Because these times when election petitions used to be, the court nullifies, the High Court nullifies the elections and says, you guys go back to the DR and recount these votes. And I remember that time I was a magistrate in Mombasa. You'd spend 2 months literally doing the work of IBC officials, recounting old ballot papers, and nothing used to gall me. Because I'm thinking with all my intellectual capacity, I should not be counting votes.
Okay.
And that's
fair enough.
Let us audit our systems prior to elections, so that after the elections, let's just ask ourselves the hard questions.
Well, we certainly hope that those who will be in charge of the electoral process in 2022 are watching this show.
Those who are running.
And then, of course, those who will be running as well. Although I must say, I feel a lot of gains have been made in the build-up to the election. You cannot compare where we were in 2013 with where we are now. But, of course, I mean, we're a growing democracy and lots and lots of learning lessons there. Let's look at other issues around the Supreme Court, but on a more lighter note. Page 4 of the Daily Nation, and we do this because we need to take a quick break and I'll allow you each to comment on 2 things. Lawyers grapple with lack of space in cramped courtroom. Of course, this doesn't relate to the actual proceedings themselves per se. It will have no impact on the decision made on the 1st of September. But nevertheless, let me start with you, Kai.
This was a challenge in 2013. A big challenge. In fact, right now it's better because some lawyers have been removed. And I'll tell you why they will always have these issues. If you have a lawyer representing the petitioner, and the lawyer comes with assistance and people, it becomes a challenge. So what ideally, because we are constrained, the judiciary is constrained of space, ideally they are supposed to have at least 2 lawyers representing each party.
Okay. But
look at, then they will be seated on the front bench. But look at what IBC did. IBC has about 5 teams of lawyers, and all are in court. So it becomes a very big difference. So the issue, the difficulty. So that's why you saw Ahmed Nasir complaining about the, and you also saw the sweating that was taking place in that court. It's because the court is small, and we have allowed all lawyers were allowed by the judges to sit in. So it became a challenge.
I think the bigger issue is just the choice by the judges, because the court where the Supreme Court normally sits is actually not the largest court available. There is what we call the Chief Justice's Court, Court number 1 of the High Court. Court number 1 is very big, in my estimation. It is at least 2 times bigger than what we are having. The idea that it is only lawyers and observers who will be in court when an important matter is being handled, I don't think it is fair.
It needs to be
we needed to go to the bigger court, which is available, because I think we will not be talking the truth to say we don't have a bigger court when I know for a fact there is a bigger court that is available, but the Supreme Court just wants to use the smaller court that it ordinarily uses. So going forward,
it's a culture.
Yes, I think it is for the big cases, the Supreme Court should be sitting on the bigger court, the Chief Justice's Court that is available. You cannot have a situations whereby very few, even members of the public, are allowed into the courtroom, because we're supposed to have an open justice system, and you cannot have it where it is only lawyers who are in court. I think this is something that we need to have about 100. The fact that you are broadcasting it does not take away the fact that the open court system should be, if 10 or so people think it is so important to witness the issue and to be there, let them be there. And again, the reach of television in Kenya is not all that much. Let's not assume those of us in the middle class that these televisions are available everywhere. And at least for purposes of just maintaining the principle, let the principle be that when you are showing the cameras, you can show the judges, you can show the lawyers, but you can have some public.
Finally, Joy, you seem to disagree with Kibe?
No, I don't entirely disagree. All I'm thinking, it's not a do or die thing that members of the public must come in. And the problem also with such cases is when you have 4 or 5 people coming in, and they are for one person, sometimes you find that the big names standing in front, like this is what we had when we were people with Kissinger, was you would prepare, it's the two youngsters will prepare the brief. They're the ones who are sleeping in the office, toiling away.
You're giving us the secrets of...
Yes, so the guy at the front actually needs this guy at the back. Because if you forget something, he's the one who will write a note and pass it along and say, oh, which page was it? He's the one who knows it was on page 5. It's true. Sometimes when you see a battalion, sometimes it's necessary to have...
So don't just believe the big faces at the front.
It's not like they're not coming for the right.
Just like the army. We say the generals take the glory for fighting, but the war is actually won by the infantry.
That's correct. And so sometimes you can see all these people.
It's the same in media.
But I agree with Kibe. There is a chief magistrate's court. That's a much larger courtroom with a public gallery at the top.
That's not the chief justices. Chief justice's court is the bigger one.
With the gallery. So it would actually take a lot of the pressure off. Even the media trying to be crammed at the space at the bottom.
Right.
So they might want, the registrar should be able to sort of impress on the good judges that maybe it may be more comfortable for everybody, because you know the way the courtrooms are constructed, even ventilation is a problem, and we don't have air conditioning, and the Supreme Court building is one of the older buildings. Maybe if they were in the newer one, they might have had better facilities.
But ventilation is actually better in the Chief Justice's court one.
Yes.
It's a big court. Yes.
Okay. Okay. Yes. Well, what can I say? I'm learning a lot today, absolutely. Even as we continue talking about the Supreme Court presidential petition. We'll be right back after a short break. I certainly hope you're learning. We'll be taking your questions as well. You're watching the Power Breakfast Show live on Citizen TV.